Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, and I'm going to be your employment lawyer for the next 30 minutes or so. There's me on the bottom there, and as you can see, I'm an associate at the law firm Samfiru Tumarkin, which is Canada's leading employee side employment firm. As you can see in the corner, for some reason, we have a cat joining us. I will remedy that right now. So while I'm waiting for your questions to roll in, and yes, please send us your questions as soon as you have them. Please send us your questions as soon as you have them. I'm waiting for some to roll in. I can address some of the topics that have been in the news lately. Oh, wait, here's one before we do that. Hold on a second. Okay, thank you. So, question from Samantha. I was recently injured on the job, and my employer told me that I only have 3 days available to take time off to recover. Can they let me go if I need more time? So, I think what that's referring to, and I don't have a lot of familiarity with it, is the various employment standard statutes across the country, and I'll just talk about BC, which is where I'm called to the bar, have, I know in BC for sure, we have a period of time where you can be sick, where you must get paid, and I can't remember if that's 3 or 5 days, and it's relatively new, and so he's talking about that, but if you can't lose your job, or theoretically you can't lose your job because you've been injured either on the job or off the job. So for example, if what happens if you need to get surgery, all of a sudden you have a major medical issue and you need to get surgery, and it's going to take you 5 months to recover. Well, provided that you provide the proper medical documentation, and by medical documentation, I mean medical notes from your doctor saying, you will have to go on medical leave for X amount of time, and then it'll be revisited, or however, the doctor's going to say it. You give that to the employer. Your employer can't fire you because you're not available because you have a health issue. Doing that would be discriminatory under the Human Rights Code. And if your employer were to do that, and certainly some employers do that, you have a right of action at minimum through the Human Rights Tribunal. Damages through the Human Rights Tribunal tend to be smaller, and there's a huge backlog with the tribunal right now, so it might take a long time to get those damages. But depending on the egregiousness of the situation, they can be significant. So if the employer has, you get, some terrible illness, you have cancer or something, and then you have to take 6 months to recover. If your employer fires you because you got that unfortunate medical diagnosis, the tribunal could also, there have been situations where they've just awarded a huge amount of damages, perhaps as punishment to the employer for its egregious conduct. So there's no real way to evaluate what the tribunal is going to do, because I can't measure. It's called injury to dignity damages. I can't measure. And certainly you'd be entitled to lost wages damages. So how much time as to the date of the decision you'd missed from your work, which would be commensurate with your salary over that period of time. But the actual affront to your dignity itself is also compensable, but it's impossible to measure that with any sort of degree of certainty. And so it's really just how egregious is it, and what does the tribunal think, and the Human Rights Tribunal, and in that sort of uncertainty, you can have, there's a lot of risk for employers. So generally, employers don't terminate somebody who's injured, particularly when they're injured on the job. And if you're injured on the job, you're going to have WCB rights as well, or whatever it's called in each individual province, and you're going to get paid from in BC we call it WCB, but you're going to get paid from that. As well, most likely, depending on the nature of your injury and if it occurred at work and all that other stuff. So, but the core of your question is, I don't think your employer is saying that you can only be injured for 3 days, and if you're not, you're going to lose your job. I think your employer is saying, we're only going to pay you for 3 days, right? And then at that point, if you want more, well, it depends, do you have short-term disability, and do you qualify for it? Or if it happened at work, is that, is a percentage of your wage, replacement wages paid for by, again, in British Columbia, it would be workers' compensation. And so, which you'd have to discuss with them. So I think that's what your employer is saying, but Samantha, you need to play it safe here. You need to get, if you're injured, you can't work, go get a doctor's note immediately, provide it to your employer immediately saying, Samantha's been injured, whatever your doctor wants to say due to X injury or not, but that you're unable to work medically, for medical reasons, for whatever the defined period of time is. So, quite often you'll see a doctor say for 3 months, at which point we'll reevaluate Samantha for her ability to capacity to return to work. So I get the doctor's note right away, and I'd send it to the employer, provide it to the employer right away. I would do it if you wanted. I would make sure that you have a paper trail, right? So do it in writing, submit it in by email, and here's my email saying, this is my doctor's note dated this date, saying that I can't work because of my injury, and then provide that to your employer and make sure your employer got it. Like, there are no bounces to your email, et cetera. So you just want to cover yourself off, because if the employer's got a medical note that says, yeah, you can't work, it ties the employer's hands down quite a bit. So I would play it safe in that regard, Samantha. This name is unique, so I'm not going to repeat it. Just use the first initial R. Okay, so what can I do if my manager has been harassing me after hours and making derogatory comments? Okay, so this is a tough question. So, I think you need to start with what it is you want, right? Like, do you want to continue working there but just have your manager stop harassing you? Or do you want to see if you can use the harassment as sort of a platform to get you to termination so you can claim severance, right? And I'll just back up here and explain what I'm talking about. So your employer can terminate your employment at any time. I know you haven't been terminated, but your employer can terminate your employment at any time, and your only legal right flowing from that is severance. I'm vastly simplifying it, but we'll just say severance for termination. So in order to get severance, you need to get to termination, okay? And you have not been terminated, okay? But their actions by an employer can be tantamount to termination. So if you're being subjected to ongoing harassment, particularly if it qualifies as harassment under the human rights, it's discriminatory under the human rights code. So if you're female and you're being harassed in a sexual way, that's discriminatory and it's harassment. On the basis of being a woman, for example, or a basis of sex, they call it. You're entitled to a harassment-free, safe working environment. So if your employer knows about the harassment and is not doing anything to stop it, then you can, or is indicated to you it's not going to do anything to stop it, you can use that to claim constructive dismissal and go after severance money. Okay, so, and whether or not you'd want to do that depends on, well, number one, are you just done there? You don't want to work there anymore. And number two, is your employment subject to an employment contract? And if so, what does it say? That's sort of the gatekeeper question, and then gateway question. And then, if it's not subject to an employment contract, or your employment contract doesn't limit your severance entitlement, then it would be a question of, a combination of an assessment of your age, your length of service, and the nature of your position or the position that you held. And why you'd evaluate all that is because that's really the formula that determines how much value there would be in the event of your termination from a severance perspective. And why I'm saying this is because if your best day of severance is like 3 weeks, then there's no point in triggering your termination. But if it's 24 months, you might want to do that because you might not get another chance to go after it. So, for you specifically, for the first part of what I'm saying here about whether or not you have entitlement to severance, you should definitely talk to an employment lawyer. I'll bring up our details again right now, so you can If you want to reach us, you can do so at employmentlawyer.ca, as you see on the screen, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so second part, it sort of moves from the remedies, right? So if your remedy is, you want to trigger severance and go after, use this as a constructive dismissal opportunity to go after severance, talk to a lawyer first. Because if you try to do that, and this is very important, if you try to trigger your constructive dismissal and you're wrong, you quit, okay, and you get 0. So you need to talk to a lawyer first before you try anything like that. However, if the answer is you want to stay, you just want the harassment to stop, this is a tough one, right? And this is sort of strays a little bit outside of legal entitlement here. But most employers will have most medium-sized and above employers will have a human resources representative for just these kind of things. And so if you report this to that person, and when you do the reporting, I tend to believe that you want a paper trail. So, you have a conversation with your HR rep and you follow up with an email explaining what's been going on. That they can step in and perhaps talk to this manager. The problem with doing that is, number one, I know nothing about who this manager is. It could be the brother of the owner, right? In which case, if you make that report, you're probably going to end up getting fired. Number two, if you have to continue to work with this manager, and they talk to him or her about the harassment you've been experiencing, that manager is going to hate you, right? And so that could be an ongoing problem for you. And so if you just want to stay, you have to decide whether or not internally, politically, at the place that you work, it is in your best interest to report the harassment, to try to stop it, or if there's perhaps a better way to deal with it. The issue with not reporting it is, if it continues to be a problem, or there's a problem with your employment later and you haven't reported it, then you don't have that framework to fall back on. So you can't just say, oh, but what about this, because you never reported it. So are you in a tough spot there? Certainly, if you want to go after severance, like trigger your termination and go after severance, you definitely want to talk to a lawyer. But in terms of trying to, and I'll just say this, sorry about that first part. If you're trying to claim constructive dismissal, and it's just harassment, you're going to need a lot of evidence. So this is something you should do anyway. If you're going to stay there for a while, I would keep a journal, okay? And in the journal, I would note every time you're being harassed: date, time, who it was, what was said, and then what you did about it, okay? And that type of thing can be, significant evidence if you ever have to try to claim constructive dismissal, or if there's something that happens down the road. And if there are any pieces of harassment in writing or any witnesses, you'll have those handy as well and save those. But if you want to stay, you've got to sort out. I know it's not really earth-shattering advice here, but you're going to have to sort out whether or not the political risks are worth it, you talking to the company itself to get them to put a stop to it, right? And that depends on the egregiousness of the harassment. Like, if it's bona fide sexual harassment, you should deal with it right away, right? The employer is going to have to deal with something like that. But if it's your boss after hours says you're a jerk, it depends. It depends on, just generally with harassment, it's got two components that sometimes interlink, which is, number one, the egregiousness of the conduct. Okay, so you need to evaluate objectively how egregious the harassment is. And then number two is their repetition, right? So famously, there have been cases, there was one in Ontario a few months ago, one instance of sexual harassment / assault was enough to trigger a termination because it was so egregious, right? But if it's more minor, like compliments that are unwanted about, of a physical nature, one's not going to get you out of that. Is not going to be enough to get that person fired, or to constitute harassment, we'll say. But repetition where it goes on and on and on, and you've indicated you don't want those compliments, that could get you there as well. So to harassment. So evaluate objectively whether or not this is harassment, and then make your call about that. So I hope that answers your question. Archie asks, I've been at my current employer for a few years, but don't have an employment agreement. Should I be worried about that? Does it mean my employer can make changes to my job? Okay, this is extremely important. No, you shouldn't be worried about that. That's a wonderful place to be, okay? Employment agreements, 99 times out of 100, are for your employer's benefit, not yours, okay? You are exchanging your labor for money on an indefinite basis. It's no different than if I sell you my bike for $20. It's still an agreement. It's still a contract between two parties. The difference is, in my bike example, it's a one-time transaction. In an employment agreement, it's indefinite. It goes on forever, right? And so, what an employment contract is, or as you call it, an employment agreement, is it's a written document that the employer exploits its superior bargaining power over the employee at the time of contract formation to force the employee to agree to terms that are contrary to its best interests, right? So in an employment agreement, generally they'll try to limit your severance entitlement, which again is your only real check on employer behavior. Your only legal right in the event of your termination is severance. But you limit your severance entitlement, define certain other aspects. You still have a contract of employment between the two of you. It's just unwritten, so the terms aren't certain. The core of your employment agreement, or the contract of employment that exists right now, is that you go to work for a certain amount of hours, for a certain amount of pay, to do a certain amount of duties. Okay, everything else is uncertain. So if you were to go to your employer and say, hey, I want an employment agreement, they might go talk to an employment lawyer, and the employment lawyer will tell them, you know what, you have a lot of liability potentially to Archie, so let's restrict his liability and force him to agree to a contract that is contrary to his best interest. Okay, so, and if they ever serve you with put a contract in front of you and say, hey, sign this, we're going to give you this paltry raise to make it valid, you need to talk to an employment lawyer immediately. Do not sign it until you talk to an employment lawyer, until you understand how your rights are being affected by signing that contract. Always talk to the lawyer first. Don't do it after, because there's some things we just can't undo. So if you need to talk to us, again, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But yeah, no, Archie, you're in a great spot. Just do nothing. Cindy, can my employer decide to make me a contract employee for 5 years as a full-time staff member? No, after working for 5 years as a full-time staff member. Well, they can say that, but you're still going to be an indefinite employee. I don't really know what contract employee means. Like they don't give you benefits, and do you have is it for a defined term? Like you're going to work here for 2 years and then your contract is done and we'll reassess? I mean, arguably no, you're an indefinite employee anyway, but depending on what's in the terms of that, I need to see the contract if that's the case. Because if, for example, they make you sign a contract that's for a fixed term of 2 years, you might want to do that, because if they try to fire you in 1 year, then you get theoretically you get the remainder, possibly. I mean, you'd probably still be an indefinite employee, but you get the remainder of the balance of the contract. So you might end up getting, say 12 months of severance or something like that. So, can they make, you guys can agree to that, I guess. I've seen that before, but unilaterally imposed after you've been an indefinite employee, I would think you're still an indefinite employee. So it's an interesting question. But Cindy, I would have to look at the documents. So as I said to the previous person, you should talk to an employment lawyer for sure with those documents if they're doing that. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, Jay. What happens if the manager changes your job description, triggering a constructive dismissal, but argues severance is not owed because they're still willing to give you the work while calling similar? Oh, that's a great question. Okay. So just to clarify what constructive dismissal is, remember what I keep saying in this call. Your right to severance flows from termination. If you have not been terminated, if you haven't been fired without cause, okay, you don't get severance. That's it. It's just an easy one-to-one relationship. Fired without cause, severance. However, there are actions that the employer can take which are tantamount to a constructive dismissal. Okay, so that would be effectively the employer, through its actions, indicating it is no longer willing to be bound into a contract of employment. Okay, so they don't want to be your employer anymore. Okay, and so there are two ways to get there. We talked about one earlier, which is ongoing harassment that it knows about, that it doesn't take steps to correct. Okay, you're entitled to a harassment-free work environment, and if such harassment continues, then you can claim constructive dismissal. But be very careful there, because you need a lot of evidence. I imagine 35% of every employee I talk to thinks they've been harassed, and almost all of them, it doesn't rise to the level of something that actually is objectively harassment. It's just humans often don't get along with each other in confined spaces, we'll say, or employment spaces, and it's just sort of the normal ebb and flow, Sturm and Drang of being an employee with other humans. But the other way, which is what you're talking about, Jay, is that if your employer imposes a unilateral change upon you, unilaterally imposes a change on a fundamental term of your employment upon you that you reject, okay, it has effectively de facto terminated your employment. Okay, so that's what a constructive dismissal is. Now, I'll give you an example, and that'll make it a lot more concrete for everybody. If your employer says, I'm reducing your pay by 50%, or let me put that a different way. If your employer reduces your pay by 50%, just imposes it and says, here you go, Jay, you were making $50,000 a year, now you're making $25,000 a year. Okay, well, that's not the contract of employment that you are working under. They've repudiated the contract. You're no longer an employee. However, here's the key. You have 3 months, 2 to 3 months. Actually, let me rephrase that. You have 2 months, and I can't give you a definitive timeline there, but it gets more risky the more time that goes by, to reject the change. And if you don't, after 2 months, there's a case in BC that says 3, but there were unique facts, then you're deemed to have accepted the change. Okay, so you can't 6 months down the road and say, hey, you constructively dismissed me 6 months ago. Well, no, you had to reject it right away. So if something like that happens, where they've unilaterally imposed a major change upon you, then you need to talk to a lawyer immediately to find out if it's a constructive dismissal, because if you let too much time go by, you just went along with the change. Okay, so in your case, changing a job description, people put too much weight in job description. Job description isn't anything. Okay, it's just this is what I think your job's going to be. But like reality, in any employer is that just because the job description says your duties are A, B, C, D, E, doesn't mean that your duties aren't going to be something totally different in the reality of a dynamic workplace, I will say. I mean, an employer doesn't have to keep changing the job description every time your job changes a little bit. Okay, what would be a constructive dismissal, okay, is if the employer fundamentally changes your job duties. Okay, so you were, I mean, these are extreme examples, but you were the manager of a small team and now you're the janitor. Okay, that would be a constructive dismissal. If there's a hollowing out of your position, then that could be a constructive dismissal. But it's a harder analysis if your pay is unchanged, right? Because then the employer can just say, well, of course we didn't constructively dismiss him. His pay is the same. And so you have an obligation to make reasonable efforts once you've been fired to make reasonable efforts to look for replacement employment. Well, the best way it's called mitigating your losses. The best way to mitigate your losses of losing your job, the job that you just lost, is to work in the job you just lost. So if they reduce your title from manager of applications to manager of, staplers, let's say, that might not be a constructive dismissal and your pay is unchanged. But if it's a giant reduction in prestige, like a manager of applications, you were managing 100 people and now you're just sitting there with 10 staplers, that could be a constructive dismissal. So when you're saying job description triggered a constructive dismissal, I disagree with that. I don't think a job description change triggers a constructive dismissal. But if they imposed upon you new duties that were a hollowing out of the prestige of your position, or just hollowing out your position in general, that could be a constructive dismissal. But again, you need to talk to a lawyer to evaluate it. And again, if you trigger your constructive dismissal by walking out or rejecting it, if you're wrong, you quit. So Jay, you need to talk to an employment lawyer. Again, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But yeah, they argue severance is not owed because they're still, like, if you're already talking about severance, like, you might be really far down the line and you should talk to a lawyer right away. But if they're giving you similar work, like if they're just changing your duties a little bit, it's not going to be a constructive dismissal. I agree with your employer. So you should talk to a lawyer, because I can't get the in one paragraph, I can't get the nuance of your position or of your fact pattern, Jay. I don't know who this person is. I'll just call them C. Is there a time limit to human rights tribunal cases? I've been waiting for over 2 years for a day in court. Yes. So, well, yes and no. So the two parts to your question. The first part, yes, you have 1 year from the date of your loss. We'll say that. Sorry, let me rephrase that. 1 day from the date of the discrimination you suffered. Okay. So it has to be under a human rights protected ground under Section 13 of the Human Rights Code in BC, anyway. So that would be like your age, race, ethnicity, sexual orientation, gender identity, ancestry, family status, religious belief, criminal record, disability. I'm sure I'm missing some, but that's the list. So if you've been discriminated against on one of those grounds, you have a human rights complaint, and you got to file. Sorry, let me be clear here. I don't know outside of BC what the limitation period is. In BC, human rights are a separate jurisdiction through the Human Rights Tribunal. Okay, and it's different in other provinces. You've got 1 year from the date of the discrimination to file the complaint. Otherwise, you're out of time, and it's a hard cut. Okay, so, well, sometimes they let them in late, depending on the circumstances of your situation. Okay, but human rights, like, there's no barrier to filing a complaint in most jurisdictions, because you don't have to pay money to do it. It's free, and so because of that, in part, and there's just a massive amount of human rights complaints and a backlog. And so, yes, 2 years is not unheard of at all. It can be longer than that. If you have another claim, you can pair with it, like a wrongful dismissal claim. You can sort of use them in tandem to extract value, if that's what you're trying to get. I don't know what you're trying to get, and in which case you should talk to an employment lawyer. But once you get over 2 years, you're sort of run afoul of other limitation periods. So, I mean, the short answer to your question, C, is yeah, they're backlogged. They're busy. They're particularly busy after the pandemic, and there's no time limit on them getting to your adjudication. There's just a time limit on you filing. So C clarified, he or she filed within 2 months of the. Okay, so you've got your claim. You're just waiting on the tribunal. There's nothing you can do about that. That's just the way the tribunal is. And then Jay came back and clarified again. He wasn't. Sorry, Jay was the one who had a job description change, and he said, yeah, his job duties changed. Well, I don't know how your job duties changed, Jay, but I'll say this. If it's a minor question of degree, you're going to lose. And remember, if you lose, you quit and you get nothing. It's even worse than get nothing. You probably end up owing if it goes to trial. But if it's more than a minor question of degree, so I've been involved in cases where there was somebody who was a manager of multiple different departments, and then got bumped down 2 levels in their duties, and was just looking after supervisor, basically effectively was made a supervisor of 2 organizational buckets down, and we were arguing over whether or not that was a constructive dismissal, and in my opinion, that was right. But it's a question of nuance and degree, and so it turns heavily on the facts of, like, well, they'll say no, it's not that big a reduction, or yeah, it's not that big a reduction, and so it couldn't constitute a constructive dismissal. And so if you get bogged down in the facts, and the facts and the details really matter. The greater the change, Jay, the more likely you are to win the case. Okay, so if you've got anything, if there's anything to your claim, you want to talk to an employment lawyer. You're not going to be able to win this without one. I mean, I shouldn't say so definitively, but if you're already talking about severance and they just said no severance, they're not like you don't have access to the legal system in the way that an employment lawyer does, right? An employment lawyer represents the threat of future financial pain to the employer, and so that's why we can get deals done that you can't on your own, accounting for risk. So I would talk to an employment lawyer, employmentlawyer.ca, helpanemploymentlawyer.ca, and 1-855-821-5900 if you want to get a hold of us. C just got back and said that she was harassed he or she was harassed on the basis of disability, and he or she has evidence about that, video, audio, that sort of thing. I mean, C, to answer your question, Human Rights Tribunal is backlogged, and they'll get to you when they get to you. You can always, if you're 2 years in, I'm sure you've been assigned somebody at the tribunal. You can always email them and see if the agent can follow up with you, can speed things along, right? But that's it. You don't really have a good option. The Human Rights Tribunal, at least in British Columbia, is extremely backlogged, and more so after the pandemic, and that's just the way it is. It's sort of first in, first out. Okay, listen, we're out of time. Great questions. Thank you all for submitting them. I certainly appreciate it. Join us on Monday. Chiron's going to show up. There you go. Chris Justice, October 3rd, 1:30 p.m. 1:30 p.m. Eastern time, is going to be answering all your questions about employment law, same format. And then I will be back, I believe, in 2 weeks, answering all your questions then. So please join me then. But, as always, thank you for the great questions. And I wish everyone a wonderful and safe weekend. Thank you.